Get ready. Start. Further, the orders of the second respondent, Special Deputy Collector, stamps did indicate the basis on which the value mentioned in the documents in question was enhanced. The reading of the same would reveal that his valuation was based on spot inspection and local inquiry. But what was the manner of local inquiry and what was the material collected in the course of such local inquiry to arrive at higher valuation at rupees 400 only per square feet and 76 only square feet for the property covered in both the documents and made available before this court. It is stated in the orders passed in respect of both the documents that the property at Sakarapuram was situated at 150 feet from Chengi bus stand and was on north of the street leading to MP Nagar. When the property covered in both the documents is stated to be situated in the same village more or less adjacently, how the value was fixed at rupees 400 only per square feet for one property and rupees 76 only per square feet for others. Property is remained unexplained in the orders passed by the second respondent. Further, the appellant was not given any notice either for spot inspection or for local inquiry as contemplated under the relevant rules, and their failure to do so is contrary to the procedure laid down under law and is in violation of the principles of natural justice. The High Court concluded by observing, thus, the discussion held above would only reveal that the determination of the market value of the property in question is in pursuance of the reference made by the third respondent registering authority under section 47A of the Stamp Act without following the procedure laid down under the Act and without performing the statutory obligation cast upon the third respondent and the impugned orders of the respondents 1 and 2 in enhancing the market value and demanding the additional stamp duty based enhancement are without any basis and based on irrelevant consideration and assumption and presumption and without application of mind. Further, as onus to prove that the instrument was undervalued is on the department and the same has not been satisfactorily discharged by the respondents. The impugned orders of the respondents are liable to be set aside. Thus, what waited with the High Court is the fact that the Form 1 notices failed to assign any reasons as such. In other words, what was the basis for the special deputy collector stamps to say that scale consideration shown in the two sale deeds was not correct? According to the High Court, there was no basis or any relevant materials on record to take the view that the two documents were undervalued except the spot inquiry and local inspection. The only contention raised by the learned counsel appearing for the appellants is that it is not mandatory to assign reasons in the notice issued in Form 1. Section 17 of the Stamp Act reads as under: instruments executed in India all are chargeable with duty and executed by any person in India shall be stamped before or at the time of execution. Section 47A of the Stamp Act reads as instruments of conveyance, etc. Undervalued how to be dealt with. One, if the registering officer appointed under the Indian Registration Act 1908 while registering any instrument of conveyance, exchange, gift, release of Benami right or settlement has reason to believe that the market value of the property which is the subject matter of conveyance, exchange, gift, release of Benami right or settlement has not been truly set forth in the instrument, he may, after registering such instrument, refer the same to the collector for determination of the market value of such property and the proper duty thereon. On receipt of reference under subsection 1, the collector shall, after giving the parties a reasonable opportunity of being heard, and after holding an inquiry in such manner as may be prescribed by rules made under this Act, determine the market value of the property which is the subject matter of conveyance, exchange, gift, release of Benami right or settlement, and the duty as aforesaid. The difference, if any, in the amount of duty shall be payable by the person liable to pay the duty. The collector may suo motu or otherwise within 5 years from the date of registration of any instrument of conveyance, exchange, gift, release of Benami, right or settlement, not already referred to him under subsection 1, call for and examine the instrument for the purpose of satisfying himself as to the correctness of the market value of the property which is the subject matter of conveyance, exchange, gift, release of Benami right or settlement, and the duty payable thereon, and if after such examination he has reason to believe that the market value of the property has not been truly set forth in the instrument, he may determine the market value of such property and the duty as aforesaid in accordance with the procedure provided for in subsection 2. Stop.